A petition to determine heirs. Hi, I'm Darren Findling of the Probate Pro. We're going to examine SCAO Form PC 553, SCAO for State Court Administrative Office, PC for Probate Court. This is Form 553, the petition to determine heirs. This is the separate proceeding petition. So this is different than the request for the determination of heirs that typically would occur within a petition for probate. So let's examine how this form is used in a deceased probate context, why you'd file this form. With all of these SCAO forms, they are guided or created by various statutes and or court rules, and in this case, MCL, Michigan Compiled Law, 700.1302, subsection small a, small v, and MCL 700.3106, and then a court rule, Michigan Court Rule MCR 5.308B2. A lot, it's a mouthful. So in a petition that is filed to commence a probate administration, whether you're asking for a will to be admitted or for it to be intestate, the court is supposed to determine heirs. Heirs are a really particular term. It's defined under Michigan's statute, the Estates and Protected Individual Code, and heirs are a defined class of people that are related to the person that died. So if a will, for example, gives everything to a charity, the court still has to determine who the heirs are under the statutes and court rule. So an heir is determined based on the relative relationships of each of the individuals. And the Michigan statute actually identifies who is an heir based on the particular circumstances. So in a typical petition that's filed before the probate court, in which you're asking the court to either admit a will or for there to be no will, what we call intestacy, there's a requirement under that court rule that you see below here, MCR 5.308B, for there to be a determination of heir request. Now you can ask for a determination of heirs even without the probate administration occurring. So for example, there may be other reasons you want to be determined to be a child, for example, of the decedent after death. This process of determining that you're an heir of the person that died would be done in this separate proceeding. So this form, PC 553, is used in that context, meaning there isn't an additional probate administration that's going on. It is a separate proceeding specifically for the purpose of determining heirs. Now that first statute that we referenced here, MCL 700.1302 small v, is the exclusive subject matter jurisdiction statute that says that the probate court has exclusive jurisdiction, and I'm going to read it directly, to determine a question that arises in the administration or distribution of a trust, including a question of construction of a will or trust. Actually, I'm reading the wrong provision here. It's actually to ascertain beneficiaries and to determine heirs. So that determination of heirs within the probate administration under subsection 700.1302 subsection A and subsection V is for the determination of heirs. So the court has jurisdiction to determine the heirs of somebody that has died. Top left corner of this form is the county, and the top right corner is the file number. As we work our way through the document, the name of the person that has died is the estate of, and the person that's making the request of this petition, and their status as petitioner. So maybe you're the son, surviving spouse, whatever it may be. The date that the person died, and the reason it's intestate is if you have filed for intestacy, which means there is a will, you would use the petition for probate in a formal probate administration, and there'd be a request to determine heirs within that particular pleading. So here, subsection paragraph 2 says the decedent died intestate, meaning without a will, the date of death and the residency. So again, it has to be in the county in which that person died. That would be the correct venue, and the court, of course, has jurisdiction if there's no full probate administration occurring. Number 3 indicates the property value, approximate value, and 4 is the relationship levels. Now, again, as you can see, this form gets complicated, and even terms like testacy, intestacy determination of heirs, heirs versus devisees, very complicated. And we strongly urge you to work with a skilled, competent probate lawyer who knows how to navigate through this process and understands the statutes so that they can guide you through this process. And here in this section, you're identifying the parties upon which you are asking the court to determine to be heirs of the person that died. Under subsection 5 is a request if any of them are under legal disability and if there's a relationship, for example, if somebody's under guardianship. Subsection 6 is that statement I keep referring to, that no other proceedings have been instituted in this or any other court to administer the estate of the decedent. So there's been no formal administration, the petition or application or otherwise, in which a personal representative is appointed. So this form is used outside of a traditional formal probate administration or an informal administration. You're making a request for the court to determine and adjudge who the heirs are and the date of death and so on. So you can get a court order making a determination of heirs without the full probate administration. In this particular case, a spot for the signature of the petitioner, as well as if there's an attorney involved in the file. Again, a very narrow form used when there isn't formal, full probate administration in Michigan. At the Probate Pro, we are passionate about everything probate. If you have questions about this petition or any probate or trust-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.